A state religion is a religious body, a creed officially endorsed by the state. A state with an official religion, while not secular, is not necessarily a theocracy, a country whose rulers have in their hands both secular and spiritual authority. Official religions have been known throughout human history in almost all types of cultures. They were adopted by most ancient states, both monoethnic and polyethnic, and observing them was a requirement made to all citizens, and especially public officials. Official religions justified and reinforced the type of government existing in a society, sanctifying it as the most, or the only, correct one. They often put forward and/or supported ideas of its expansion to other lands, whether the latter already follow the same religion or, sometimes not, as the term church is typically applied to a Christian place of worship and organizations incorporating such ones. The term state church is associated with Christianity, historically the state church of the Roman Empire in the last centuries of the empire's existence, and is sometimes used to denote a specific modern national branch of Christianity, closely related to state churches are what sociologists call ecclesiae, though the two are slightly different. State religions are official or government-sanctioned establishments of a religion, but neither does the state need be under the control of the religion, nor is the state-sanctioned religion necessarily under the control of the state. The institution of state-sponsored religious cults is ancient, reaching into the ancient Near East and prehistory. The relation of religious cult and the state was discussed by Varro under the term of theologia civilis. The first state-sponsored Christian church was the Armenian Apostolic Church, established in 301 AD. In the Near East and Middle East, many states with mostly Islamic population have Islam as the state religion in its Shiite and Sunni variety, though the degree of religious restrictions on the citizens' everyday life varies. On the one hand, rulers of Saudi Arabia join secular and religious power in their hands, and Iran's secular presidents since the revolution of 1979 are supposed to follow decisions of religious authorities. Turkey, which also has mostly Muslim population, after its 1920s revolution became a secular country, though unlike Russian Revolution of the same decade, it did not make the country atheistic. The degree that an official religion is imposed upon citizens in contemporary society varies considerably from total as in Saudi Arabia to not at all as in Norway. Types of state religion. The degree and nature of state backing for denomination or creed designated as a state religion can vary. It can range from mere endorsement with freedom for other faiths to practice, to prohibiting any competing religious body from operating and to persecuting the followers of other sects. In Europe, competition between Catholic and Protestant denominations for state sponsorship in the 16th century evolved the principle quia regio eius religio, embodied in the text of the treaty that marked the Peace of Augsburg, 1555. In England, Henry VIII broke with Rome in 1534, being declared the supreme head on earth of the Church of England. The official religion of England continued to be Catholicism without the Pope until after his death in 1547, while in Scotland the Church of Scotland opposed the religion of the ruler. In some cases, an administrative region may sponsor and fund a set of religious denominations, such as the case in Alsace-Moselle in France under its local law. Following the pre-1905 French concordatory legal system and patterns in Germany, in some communist states, notably in North Korea and Cuba, the state sponsors religious organizations, and activities outside those state-sponsored religious organizations are met with various degrees of official disapproval. In these cases, state religions are widely seen as efforts by the state to prevent alternate sources of authority. state churches. There is also a difference between a state church and the broader term of state religion. A state church is a state religion created by a state for use exclusively by that state. An example of a state religion that's not also a state church is Roman Catholicism in Costa Rica, which was accepted as the state religion in the 1949 Constitution, despite the lack of a national church. In the case of a state church, the state has absolute control over the church, but in the case of a state religion, the church is ruled by an exterior body. In the case of Catholicism, the Vatican has control over the church. In either case, the official state religion has some influence over the ruling of the state. As of 2012, there are only 7 state churches left, as most countries that once featured state churches have separated the church from the government. Disestablishment is the process of repealing a church's status as an organ of the state. Opponents of disestablishment of the Church of England were known as anti-disestablishmentarians. Current state religions. Currently, the following religions have been established as state religions in some countries. All are versions of Christianity, Islam or Buddhism. Christian countries. The following states recognize some form of Christianity as the state or official religion. Roman Catholicism. Jurisdictions where Roman Catholicism has been established as a state or official religion. Costa Rica. Article 75 of the Constitution of Costa Rica confirms that the Roman Catholic and Apostolic religion is the religion of the state, which contributes to its maintenance, without preventing the free exercise in the Republic of other forms of worship that are not opposed to universal morality or good customs. Liechtenstein. The Constitution of Liechtenstein describes the Catholic Church as the state religion and enjoying the full protection of the state. The Constitution does, however, ensure that people of other faiths shall be entitled to practice the creeds and to hold religious services to the extent consistent with morality and public order. Malta. Article 2 of the Constitution of Malta declares that the religion of Malta is the Roman Catholic Apostolic religion. Monaco. Article 9 of the Constitution of Monaco describes la religion catholique apostolique romaine as the religion of the state. Vatican City. The Vatican is an elective, theocratic, or sacerdotal absolute monarchy ruled by the Pope, who is also the vicar of the Catholic Church. The highest state functionaries are all Catholic clergy of various national origins. It is the sovereign territory of the Holy See and the location of the Pope's official residence, referred to as the Apostolic Palace. Jurisdictions that give various degrees of recognition in their constitutions to Roman Catholicism without establishing it as the state religion. Andorra. Argentina. Article 2 of the Constitution explicitly states that the government supports the Catholic Church, but the Constitution does not establish a state religion. Dominican Republic. El Salvador. Panama. The Constitution recognizes Catholicism as the religion of the majority of citizens but does not designate it as the official state religion. Paraguay. Peru. Poland. Eastern Orthodoxy. Greece. The Church of Greece is recognized by the Greek constitution as the prevailing religion in Greece. However, this provision does not give official status to the Church of Greece, while all other religions are recognized as equal and may be practiced freely. Therefore, this provision is considered a dead letter and can only be interpreted as a nationalistic historical remnant. Georgia. Georgian Orthodox Church is not the state church of Georgia but has a special constitutional agreement with the state, with the constitution recognizing the special role of the Apostolic Autocephalous Orthodox Church of Georgia in the history of Georgia and its independence from the state. Bulgaria. In the Bulgarian constitution, the Bulgarian Orthodox Church is recognized as the traditional religion of the Bulgarian people, but the state itself remains secular. Anglicanism. England. The Church of England is the established church in England, but not in the United Kingdom as a whole. It is the only established Anglican church worldwide. The Anglican Church in Wales, the Scottish Episcopal Church and the Church of Ireland are not established churches, and they are independent from the Church of England. The British monarch is the titular supreme governor of the Church of England. The 26 most senior bishops in the Church of England are Lords Spiritual and have seats in the House of Lords of the UK Parliament. Scottish, Welsh and Irish Anglican bishops do not sit in the House of Lords. In the 19th century, there was a campaign by liberals, dissenters and nonconformists to disestablish the Church of England. The campaign for disestablishment was revived in the 20th century when Parliament rejected the 1928 revision of the Book of Common Prayer, leading to calls for separation of church and state to prevent political interference in matters of worship. Nevertheless, the Church of England remained the state church. Protestantism. Lutheranism. Jurisdictions where a Lutheran church has been established as a state religion include the Nordic countries. Denmark. Section 4 of the Danish Constitution confirms the Church of Denmark as the state church. Faroe Islands. The Church of the Faroe Islands is the state church of the Faroe Islands, an autonomous country within the Danish realm. Greenland. The Church of Denmark is the state church of Greenland, an autonomous country within the Danish realm. Iceland. The Icelandic constitution confirms the Church of Iceland as the state church of Iceland. Norway. The Constitution of Norway stipulates that the Church of Norway, an evangelical Lutheran church, will remain the established Church of Norway and will as such be supported by the state. Quote, "This was amended in 2012 from Evangelical Lutheran religion remains the public religion of the state. The Church is granted autonomy in doctrine and appointment of bishops." Finland. The Evangelical Lutheran Church of Finland has a special relationship with the Finnish state, its internal structure being described in a special law, the Church Act. The Church Act can be amended only by a decision of the Synod of the Evangelical Lutheran Church and subsequent ratification by the Parliament of Finland. The Church Act is protected by the Finnish constitution, and the state cannot change the Church Act without changing the constitution. The Church has a power to tax its members and all corporations unless a majority of shareholders are members of the Finnish Orthodox Church. The state collects these taxes for the Church for a fee. On the other hand, the Church is required to give a burial place for everyone in its graveyard. The President of the Republic of Finland also decides the themes for intercession days. The Church does not consider itself a state church, as the Finnish state does not have the power to influence its internal workings or its theology, although it has a veto in those changes of the internal structure which require changing the Church Act. Neither does the Finnish state accord any precedence to Lutherans of the Lutheran faith in its own acts. The Union of Freethinkers of Finland has criticized the official endorsement of the two churches by the Finnish state, and has campaigned for the separation of church and state. Sweden. The Church of Sweden was until 2000 the official state church of Sweden, and Lutheranism was therefore the state religion of Sweden. In spite of the separation between the state and the church in 2000, the Church of Sweden still has a special status in Sweden. Sweden is therefore often seen as a midway between having a state religion and not. The Church has its own legal regulation in the 1998 Church of Sweden Act, which regulates the Church's basic structure, creeds and right to tax members of the Church. According to the Act, the Church of Sweden must be a democratic, Lutheran People's Church. Only the Swedish Riksdag can change this fact. The connections to the Swedish royal family are complicated. For example, the Swedish constitution stipulates that the monarch of Sweden must be a true Lutheran, accepting the doctrine of the Church of Sweden. All members of the royal house must accept the same doctrine to be able to inherit the throne of Sweden. The parishes of the Church of Sweden were the smallest administrative entities in Sweden and were used as civil registration and taxation units until the 1st of January 2016. Methodism Tonga. The Free Wesleyan Church of Tonga. In 1928, Queen Salotupo III, who was a member of the church, established the Free Wesleyan Church as the state religion of Tonga. The chief pastor of the Free Wesleyan Church serves as the representative of the people of Tonga and of the church at the coronation of a king or queen of Tonga, where he anoints and crowns the monarch. In opposition to the establishment of the Free Wesleyan Church as a state religion, the Church of Tonga separated from the Free Wesleyan Church in 1928. Calvinism Tuvalu. The Church of Tuvalu is the state religion, although in practice this merely entitles it to the privilege of performing special services on major national events. The Constitution of Tuvalu guarantees freedom of religion, including the freedom to practice, the freedom to change religion, the right not to receive religious instruction at school or to attend religious ceremonies at school, and the right not to take an oath or make an affirmation that is contrary to his religion or belief. Scotland. The Church of Scotland is recognised as the National Church of Scotland, but is not a state church and thus differs from the Church of England. Its constitution, which is recognised by acts of the British Parliament, gives it complete independence from the state. Other. Mixed France. The local law in Alsace-Moselle accords official status to 4 religions in this specific region of France: Judaism, Roman Catholicism, Lutheranism and Calvinism. The law is a remnant of the Napoleonic Concordat of 1801, which was abrogated in the rest of France by the law of 1905 on the separation of church and state. However, at the time, Alsace-Moselle had been annexed by Germany. The Concordat therefore remained in force in these areas, and it was not abrogated when France regained control of the region in 1918. The Concordat recognizes 4 religious traditions in Alsace-Moselle: the Jewish religion and 3 branches of Christianity: Catholic, Lutheran and Reformed. Therefore, the separation of church and state, part of the French concept of laïcité, does not apply in this region. Hungary. The preamble to the Hungarian Constitution of 2011 describes Hungary as part of Christian Europe and acknowledges the role of Christianity in preserving nationhood, while Article 7 provides that the state shall cooperate with the churches for community goals. However, the Constitution also guarantees freedom of religion and separation of church and state. Muslim countries. Many Muslim-majority countries have constitutionally established Islam, or a specific form of it, as a state religion. Proselytism is often illegal. Islam states which define Islam as the state religion, but do not specify either Sunni or Shia. Bangladesh. The 1972 constitution did not include any religion as the state religion. However, in 1988, General Ershad inserted Islam as the state religion by the 8th Amendment Act. 1988, Section 2A specifies the state religion of the Republic is Islam, but other religions may be practiced in peace and harmony in the Republic. As part of a series of rulings, on 4 October 2010 the High Court ruled that Bangladesh is a secular state. Section 12 of Part 2 of the Constitution identifies secularism and freedom of religion as fundamental principles of state policy. Djibouti. Iraq. Article 2 of the Constitution of Iraq confirms Islam as the official religion of the state. Pakistan. Article 2 of the Constitution of Pakistan confirms Islam as the state religion. Tunisia. Art. 1. Constitution of Tunisia. Sunni Islam. Afghanistan. Article 1 and Amp. 2. Constitution of Afghanistan. Algeria. Art. 2. Constitution of Algeria. Brunei. Art. 3. Constitution of Brunei. Comoros. Egypt. Article 2. Egyptian Constitution of 2014. Jordan. Article 2. Constitution of Jordan. Libya. Maldives. Malaysia. Article 3. Constitution of Malaysia. Mauritania. Article 5. Constitution of Mauritania. Morocco. Qatar. Article 1. Constitution of Qatar. Saudi Arabia. Article 1. Basic Law of Saudi Arabia. Somalia. Article 2. Constitution of Somalia. United Arab Emirates. Shia Islam. Iran. Theocratic Republican hybrid. See Politics of Iran. Abadi Oman. Mixed Shia and Sunni Kuwait. Yemen. Bahrain. Buddhist countries. Governments where Buddhism, either a specific form of or the whole, has been established as an official religion. Theravada Buddhism. Cambodia. Sri Lanka. The Constitution of Sri Lanka accords Buddhism the foremost place, although it does not identify it as a state religion. Thailand. The 2007 Thai Constitution recognizes Buddhism as the religion of Thai tradition with the most adherents. However, it is not formally identified as a state religion. It requires the government to patronize and protect Buddhism and other religions. Myanmar. Section 361 of the Constitution states that the Union recognizes special position of Buddhism as the faith professed by the great majority of the citizens of the Union. Vajrayana Buddhism. Bhutan. Status of religion in Israel. Israel is defined in several of its laws as a Jewish and democratic state. However, the term Jewish is a polysemy that can describe the Jewish people as both an ethnic or a religious group. The debate about the meaning of the term Jewish and its legal and social applications is one of the most profound issues with which Israeli society deals. The problem of the status of religion in Israel, even though it is relevant to all religions, usually refers to the status of Judaism in Israeli society. Thus, even though from a constitutional point of view Judaism is not the state religion in Israel, its status nevertheless determines relations between religion and state and the extent to which religion influences the political center. The State of Israel supports religious institutions, particularly Orthodox Jewish ones, and recognizes the religious communities as carried over from those recognized under the British Mandate. These are Jewish and Christian. The fact that the Muslim population was not defined as a religious community is a vestige of the Ottoman period, during which Islam was the dominant religion and does not affect the rights of the Muslim community to practice the faith. At the end of the period covered by the 2009 U.S. International Religious Freedom Report, several of these denominations were pending official government recognition. However, the government has allowed adherents of not officially recognized groups freedom to practice. In 1961, legislation gave Muslim Sharia courts exclusive jurisdiction in matters of personal status. 3 additional religious communities have subsequently been recognized by Israeli law: the Druze, the Evangelical Episcopal Church, and the Baha'i. These groups have their own religious courts as official state courts for personal status matters. The structure and goals of the Chief Rabbinate of Israel are governed by Israeli law, but the law does not say explicitly that it is a state rabbinate. However, outspoken Israeli secularists such as Shulamit Aloni and Uri Avneri have long maintained that it is that in practice. Non-recognition of other streams of Judaism such as Reform Judaism and Conservative Judaism is the cause of some controversy. Rabbis belonging to these currents are not recognized as such by state institutions, and marriages performed by them are not recognized as valid. As of 2015, marriage in Israel provides no provision for civil marriage between people of different religions. Marriages by people who do not belong to one of 9 recognized religious communities, or same-sex marriages, although there is recognition of marriages performed abroad. Political religions. In some countries there is a political ideology sponsored by the government that may be called political religion. North Korea. The North Korean government has promulgated Jewish as a political alternative to traditional religion. The doctrine advocates a strong nationalist propaganda basis and is fundamentally opposed to Christianity and Buddhism, the 2 largest religions on the Korean peninsula. Jewish theoreticians have, however, incorporated religious ideas into the state ideology. According to government figures, Jewish is the largest political religion in North Korea. The public practice of all other religions is overseen and subject to heavy surveillance by the state. Additional notes: Indonesia does not declare a designated state religion. However, the government does only recognize 6 religions: Islam, Protestantism, Catholicism, Buddhism, Hinduism and Confucianism. The Constitution of Indonesia guarantees the freedom of religion and the practice of other religions and beliefs, including the animistic indigenous ones, is not prohibited by any laws. Indonesians practicing traditional polytheistic and animistic beliefs are often counted as Hindus for government purposes. Atheism or agnosticism, although not prosecuted, is discouraged by the state ideology of Pancasila. In addition, the province of Aceh receives a special status and a higher degree of autonomy, in which it may enact laws based on the Sharia and enforce it, especially to its Muslim residents. Nepal was once the world's only Hindu state, but has ceased to be so following a declaration by the parliament in 2006. Many countries indirectly fund the activities of different religious denominations by granting tax-exempt status to churches and religious institutions which qualify as charitable organizations. However, these religions are not established as state religions.